Thank you, Mr. Speaker. I'm pleased to rise today in debate on Bill C-15, the Act to amend the National Defense Act and to make consequential amendments to other acts. The short title, of course, is always the jazzier version, Strengthening Military Justice in the Defense of Canada Act. I'm going to pause before diving into the details of C-15 that concern me to say that I find the character of this debate at second reading, and I'm sure anybody observing this on the parliamentary channel will also find it unusual that we're so far, until speaking on behalf of the Green Party, I've risen to speak. At second reading, we've only been hearing from members of the official opposition. I don't know why this is. I think it's symptomatic of the unnecessarily partisan nature of debates in this House on legislation. There was a time, and I worked in Ottawa in that time, when working on legislation was not a partisan matter, but a largely cooperative and consensual matter to come to the best possible conclusions about how to improve legislative efforts before us. Amendments were not considered a threat to the government of the day. Amendment process, debate process was all seen as part of the role and proper function of Parliament, and in that sense it would be totally in keeping with parliamentary democracy to always see members on all sides of the House put their oar in at second reading and suggest where they think the committee, which will of course be the specialist members of Parliament on all sides of the House, will dig down, and what the committee should focus on when they take a bill, such as a bill of this nature, which I think is largely good work, but there are areas that need fixing, and I think we should approach debates in this House with much less partisanship. Every question I've heard from the Honourable Parliamentary Secretary towards members of the official opposition has been to accuse them of somehow being hostile to the purposes of the bill or trying to stop it from being passed. I hear this far too often in this place, and Mr. Speaker, with your permission, I just want to say clearly that when parliamentarians from any side of this House speak to legislation, that's our role, that's our job. It's not a political game, it's not a waste of time. It's the very purpose and essence of parliamentary democracy to ensure that legislation, which Canadians will have to live with for a very long time, is derived through the most exultant of intellectual processes, invoking rigor, thought, and research, so that we come up with the very best possible legislation, not the very nastiest of debates. So with that set aside, I want to speak to this bill. I want to associate myself with the purposes of Canadian military justice as set out by someone who's been quoted quite a lot in debate today, a former colonel and now professor in the Faculty of Law at Ottawa University, former Colonel Michel Drapeau. And I think in this article, which originally appeared in the Hill Times, he set out very clearly where we are as we approach this debate today. And he said, quote, "At the end of the day, Canadian military law, which incorporates both the criminal law of Canada as well as civil offences committed outside Canada, is a vital and necessary law in order to maintain discipline and order among the troops, and is believed to be one of the many reasons why the Canadian forces are considered one of the world's best, despite its small size. Considering the power that military law has over its audience, our citizen soldiers deserve a world-class military justice system. A military justice system which is first and foremost just and fair to the accused, while being responsive to the military need for discipline. Obviously, the National Defense Act is still deficient in some major areas and requires more than tweaks and tinkering to bring it into the 21st century." So I think that sets the context. This is not a wholesale assault on military justice coming from opposition benches. It's an attempt to ensure that this time that we're taking a crack at military justice, considering that the comments and the work goes back to the work of Judge Lemaire back in 2003, that we get it right in the 21st century. As a general comment, I think we may have missed out because we're still reaching back to 2003, 9 years ago, for our recommendations. They're good recommendations, but the world has moved on in a number of areas. So again, as a general comment, I hope the committee will look at the reforms that are taking place among many of our allied nations and friends, such as the United Kingdom, Ireland, New Zealand, Australia, Germany, France, have been looking at their military justice system, and now I don't like using nouns as verbs, but since Professor Drapeau did it, I'll repeat it, civilianizing. Taking a military justice system and seeing if we can't combine resources. His recommendation is that the military justice system be folded into the federal court, and that there then be within the federal court a specific area of expertise around military justice. This would achieve quite a lot of efficiencies and cost savings, something this government usually likes. Another comment, again, overarching to this whole process from Professor Drapeau, was to wonder why we are looking at this bill now when just last March, Justice Patrick Lesage was appointed to conduct a review of the military justice provisions of the National Defense Act. And the question then is, wouldn't we be wiser in this House and in this place to see what he recommended in light of all the things that have transpired over the last 9 years since Justice Lemaire's report? In any case, moving to some specific areas of concern about this legislation, I'm sure that the committee will look at this, but I hope they'll be open to amendments. Going again to the questions of efficiencies and costs, it's quite surprising to find new judicial positions being created. This particularly creation of reserve force military judge panel. Mr. Drapeau noted that this is the current military judiciary has one of the lightest caseloads of any bench in Canada. We know the Supreme Court of Canada has a heavy caseload. Federal court has a heavy caseload. Most provinces are, under the weight of their caseload, justice grinds slowly. But here we have a light caseload and the creation of an additional reserve force for military judges, which Professor Drapeau terms a costly extravagance. I think that we should look at that and see if we really need those provisions and additional judges. The second place where I want to direct most of my attention is to changes in the grievance procedures. And I want to start a discussion of grievance procedures by going back to Mr. Justice Lemaire's report. You'll find this on page 86 of the report tabled to the Minister of National Defense in September of 2003. Mr. Justice Lemaire, I think, puts it quite clearly. Quote, he wrote, "Soldiers are not second-class citizens. They are entitled to be treated with respect, and in the case of the grievance process, in a procedurally fair manner." If you were reading this at this point, Mr. Speaker, there'd be an ellipsis, because I'm going to the end of that paragraph. Quote, "It is essential to the morale of Canadian Forces members that their grievances be addressed in a fair, transparent, and prompt manner." And it's here to which quite a number of Mr. Justice Lemaire's comments were directed and his recommendations. I think it's important to set the grievance process in the context in which Mr. Justice Lemaire said it, which is that unlike the rest of what we're dealing with in this Act, which is all important, I'm concentrating on this because I've heard relatively less of it in debate at second reading. Unlike the rest of the military justice process, grievance process is inherently non-adversarial. Nobody is being charged. It's not a question of whether the members of our military forces have access to a lawyer. It's a fundamental question of whether receipts have been honored properly, whether their working conditions are appropriate. It is, in the standard management labor context, a grievance. But boy, oh boy, are their grievances treated differently. Mr. Justice Lemaire said we should use a process that is, at its essence, cooperative. Well, certainly this is a place where I can see efforts to take Justice Lemaire's comments on board. His recommendation 75 is virtually verbatim in Clause 6, which is actually in the Act itself, will be Section 2911, to move matters along as informally and expeditiously as the circumstances and fairness permit. But still, there are many other recommendations of Mr. Justice Lemaire that aren't being dealt with in this Act. One of the changes in the Act to the grievance procedures wasn't recommended by anyone, and I query why we have to continually change the names of things. For some reason, Bill C-15 changes the name the Canadian Forces Grievance Board to the Military Grievance External Review Committee. I mean, anytime you change the name of a board, it may be a small matter, but at least all the stationery needs to be redone. But why this change to C-15 instead of some of the more pertinent things that Mr. Justice Lemaire wanted done with the grievance procedure? And I want to focus in the few seconds I have left with this one. I think this is really important. Right now, grievance procedures still go all the way to the Chief of Defense Staff. The Chief of Defense Staff can delegate, but this recommendation, number 78, said, let's give the commanding officer a maximum of 20 days to try to explore alternatives to the grievance process before it starts going up the hierarchy to the Chief of Defense Staff. With that, Mr. Speaker, I think my time has elapsed. Thanks for this opportunity to contribute to the debate.
Questions
and comments, the honourable member for Abitibi-Témiscamingue. Thank you very much, Mr. Speaker. I would like to put a question to my colleague, specifically about reforming the summary trial system. I was a member of the armed forces, and when you're a member of the armed forces, I think some people don't always understand how complex the military justice system is. For example, you may end up for a minor offense in a summary trial, and you also may not quite understand what's happening to you, because a summary trial is very impressive. There are people who are marching, there are people who are escorting the commander, and it's very impressive. So does my colleague think that military members are aware of the impact that a summary trial may have on their future career when they come out of military life?
And it's called violence.
Thank you, Mr. Speaker, and I thank my honourable friend for Abitibi-Témiscamingue. Well,
it's not up to me to say what the members of the armed forces will be thinking. I think I should be asking that question to her as a former member. I think that she's probably in a much better position to understand their situation.
I do think, though, that we could simplify the summary procedures. They're not necessarily unconstitutional, but there certainly are questions raised about their constitutionality. I think our summary proceedings would be is one of those areas where we might move to something much closer to a civilian process with civilian judges and all the access to rights and clear understanding of the charges before them for members of our military. Again, military members of our Canadian forces are not second-class citizens, and they should never face charges they don't completely understand.
Questions and comments? The honourable member for Winnipeg North.
Thank you, Mr. Speaker. What I'd like to kind of pick up on from the previous question, I too was a member of the Canadian Forces, and the last thing you think about when you join the forces is what sort of court system do they have, or disciplinary action do they take. Mr. Speaker, you're quite honoured and privileged if in fact you get accepted. You, like myself, enjoy the experience. And at this point I'd like to emphasize just how small of a percentage of members of the force actually find themselves in the position of having to go through a military court. Very small percentage. You're talking somewhere in the neighborhood of, let's say, a guesstimate of 40 to 60 cases in any given year. The principle of the bill is to try to narrow the difference between civil courts and military courts. The principle is something in which the Liberal Party supports, Mr. Speaker, and that's one of the reasons why we're having no problem in terms of seeing it go to committee. And I'm wondering if the member from leader of the Green Party would provide her thoughts in regards to the importance of where we can to try to ensure that there's civil court procedures that would be afforded in the same fashion to military courts, and trying to narrow that difference.
The honourable member for Saanich Gulf Islands.
I appreciate the question from my friend from Winnipeg North. Yeah, I think that to the greatest extent possible, as a policy direction, Mr. Speaker, it makes sense to take what is, the court-martial proceedings on battlegrounds are a very specific set of circumstances and apply themselves poorly in a more civilian context. We even have civilian workers in Afghanistan, as it's been pointed out, who happen to be working at Tim Hortons, who'd fall under military justice. I think we need to ensure that for our men and women of Canadian Armed Forces, that they have a system of justice that is no less protective of their rights, no less clear in ensuring access to counsel, that the charges against them are completely clear. There really isn't a reason to have a completely separate class of justice for members of our military.